Welcome to the Explainer. If you're looking to absolutely crush Module 1 of your environmental law syllabus and score top marks on your exams, you are in the exact right place. We're going to dive straight into a highly analytical breakdown of constitutional provisions and public interest litigation. No fluff today, just exactly what you need to know to craft that perfect exam answer. Here's our roadmap. First, cracking syllabus Module 1. Second, Article 21, Right to Life. Third, the 42nd Amendment Act. Fourth, Public Interest Litigation. And fifth, Judicial Activism and Landmark Cases. Let's get into it. Section 1, Cracking Syllabus, Module 1. Okay, so here's the secret. A top-tier exam answer doesn't just regurgitate facts, it demonstrates a deep structural understanding of the legal hierarchy. To get those top marks, you have to show the examiner exactly how a fundamental constitutional right triggers a state duty, and then, crucially, precisely how that duty is legally enforced through the courts when things go wrong. You have to connect those abstract constitutional principles to their practical enforcement mechanisms. Section 2, Article 21, Right to Life. This is the absolute bedrock of Indian environmental law. The courts made a massive leap here by interpreting life and personal liberty to include basic, everyday necessities. Think about it. The judiciary essentially recognized that your right to life is completely meaningless if you're forced to exist in a hazardous, degraded environment. It encompasses the right to live with dignity, and that inherently requires clean air and clean water. So, here's a massive exam tip for you. If you get any question on fundamental rights, examiners desperately want to see you explicitly connect environmental degradation to a direct violation of Article 21. Don't just write that pollution is bad. You need to frame it legally. State that pollution is a direct infringement on a citizen's constitutional right to life. The courts have consistently hammered home three core judicial principles here. First, ecological degradation directly violates the right to life. Second, citizens have an absolute, undeniable right to fresh air and clean water. And third, under the doctrine of sustainable development, economic progress legally cannot compromise the ecosystem. These 3 points are your primary legal ammunition. Use them to argue exactly why the state cannot just greenlight activities causing severe environmental damage. Industrial development always has to be balanced against a citizen's right to a healthy environment. Section 3, the 42nd Amendment Act. All right, let's step back to before 1976. Back then, the legal focus in India was heavily weighted toward fundamental rights. People knew exactly what they were entitled to, but collective environmental responsibilities were kind of ignored. The 42nd Amendment totally shifted this legal paradigm. It famously introduced a much-needed balance of responsibilities, formally writing into the Constitution that protecting the environment is a massive, shared burden between the government and the people. This brings us to what we call the twin pillars of constitutional environmental law. On the left side, we've got Article 48A. This is a directive principle of state policy, obligating the state to actively protect and improve the environment, forests, and wildlife. On the exact opposite side, we have Article 51AG, which puts a fundamental duty on every single citizen to preserve the natural environment and have compassion for living creatures. Now pay close attention because examiners are actively looking for this specific linkage. Highlighting this strict dichotomy between the state's directive principles and the individual's fundamental duties is exactly how you secure maximum points. If either the state or the citizen drops the ball on these specific duties, the courts view it as a betrayal of the fundamental law of the land, and that is exactly what officially opens the door for judicial intervention. Section 4, Public Interest Litigation, or PIL. PIL is nothing short of revolutionary. Why? Because it means you literally do not need to be personally injured to demand environmental justice from the courts. By relaxing those incredibly strict traditional rules of locus standi, or legal standing, any public-spirited citizen or NGO can drag a polluting industry or a negligent government into court on behalf of the greater public. When you're breaking down the procedure in your exam answers, you need to explain that citizens can essentially leapfrog the lower courts. Once you identify a large-scale environmental violation and bypass those traditional standing rules, you can file a writ petition directly at the top. You use Article 32 to go straight to the Supreme Court, or use Article 226 for the high courts, demanding writs like mandamus to literally force a government authority to perform its environmental duties. Section 5, Judicial Activism and Landmark Cases. When we talk about judicial activism in environmental PILs, we mean judges aren't just sitting back in their chairs, they are proactively enforcing environmental laws and bypassing technical procedures for the public good. They don't just rely on lawyers arguing, they actively monitor implementation, appoint expert scientific committees, demand reports from government agencies, and ensure that their orders are actually fixing the long-term environmental issue on the ground. To really prove to your examiner that you understand judicial activism, you have to cite the landmark cases brought forward by the legendary environmental lawyer M.C. Mehta. First is the Gunga pollution case, where the court literally forced the closure of Kanpur tanneries that were dumping untreated waste right into the river. Second is the Taj trapezium case. Here, massive industries were ordered to either adopt cleaner technologies or shut down entirely to stop toxic emissions from destroying the Taj Mahal, which is a perfect example of the court actively applying the polluter pays principle. Here is your top marks tip. Those specific MC Mehta cases are the absolute gold standard for demonstrating the practical application of everything we've just covered today. They beautifully tie together the violation of Article 21, the failure of the state's duty under Article 48A, and the proactive, powerful solution found through a public interest litigation. I'm going to leave you with this exam synthesis question to really test out your new legal arsenal. If a local factory is heavily polluting your city's river, how would you systematically use a PIL to force a shutdown? Think about it. How do you cite Article 21? How do you leverage the duties in the 42nd Amendment? And how do you bypass traditional standing to file that Article 32 writ? Master this analytical flow and you will absolutely secure top marks on Module 1 of your environmental law syllabus.